second defence that's open to a defendant who has had negligence alleged against them is that of contributory negligence. So again, this defence comes in once we've established that the defendant owed a duty, they breached the duty, and the duty caused the harm. In this instance, the defendant can go and say, hey, did the other person contribute to that particular harm? The case of Manley and Alexander probably gives us a good idea about how this works in practice. So we have this gentleman by the name of Alexander who's had a bit to drink, right? They've consumed 12 stubbies of beer, and then they go and lie down in the middle of the road at Middleton Beach in Albany, Western Australia. Now, unfortunately, Manley, who's the motorist, is driving along that particular road, and he sees someone on the side of the road, right? It's actually a friend of Alexander who's been drinking with them. That friend looks like he's pretty drunk. So Manley, right, keeps looking at this particular person who's been drinking, as you would. But because he did that, where wasn't he looking? Okay, so he's not really looking at the road. Further, he's not looking at the road, and he actually doesn't slow down, right? He maintains his speed of 55 to 60 kilometres an hour. And because he's not looking at the road, what do you think happens? Of course, he hits Alexander. So the question is Manley liable for Alexander's injuries? So in this particular case, what we found is that while Manley is negligent, right, Manley should either have slowed down and or been watching the road or switching their vision between the side and the road. Alexander, the person, remember that's the person who's been drinking, had the half carton, they're also been negligent and contributed to their injuries. And in this case, Alexander was apportioned 70% of responsibility. So in contributory negligence, what the defendant is saying, well, okay, I might be liable, but the plaintiff was also liable. They were also negligent and should bear some of the costs. They contributed to the negligence. So the general principle of contributory negligence is if you can establish the plaintiff contributed in some way to their loss, then liability is apportioned or it's split between the two parties, between the defendant and the plaintiff. Section 23 of the Civil Liability Act helps us, points us to how to determine this. So why don't we have a look at Section 23? Again, I've just gone into the Civil Liability Act, Queensland, which we can search for in Google, and we're after Section 23. Section 23, Standard of Care in relation to contributory negligence. The principles that are applicable in deciding whether a person has breached a duty also apply in deciding whether the person who suffered harm has been guilty of contributory negligence. So what does that mean? Well, that means the standards that we've already used to see if someone has breached a duty are those that we apply to the person against whom the claim of contributory negligence is made. So in reality, or quite simply, we need to go to Section 9. And then Section 23 says, apply Section 9 and see if what the plaintiff did actually breached a duty of harm, a duty of care. So perhaps in a summary form, it becomes the same factors apply to the plaintiff as for the normal standard of care that we expect for the defendant. There are a number of very specific provisions in the Civil Liability Act to do with contributory negligence. One that we want you to be aware of is Section 47. Under Section 47, if someone suffers harm when they're intoxicated, so intoxicated includes drugs plus alcohol, so it's not just booze but also other drugs. If you're intoxicated and suffer harm, then contributory negligence is alleged, it will be presumed. Okay, so if you're drunk and it's raised that there was contributory negligence, it will be presumed that there was contributory negligence. Now, that can be rebutted. So why don't we have a bit of a deeper look at the section to understand this a little bit better. Section 47. This section applies if a person who suffered harm was intoxicated at the time of breach of duty. Okay, so if a person who suffered harm was intoxicated at the time of the breach of duty, giving rise to a claim for damages, and contributory negligence is alleged by the defendant, contributory negligence will, subject to this section, be presumed. So if you're intoxicated, it's presumed you contributed to the act. You can rebut that, or you can say, no, that isn't the case, but you will have to show that the intoxication did not contribute to the breach, or that the intoxication was not self-induced. Okay, they can be difficult in some instances to show out, obviously, that you were either drugged by someone else, that means your intoxication wasn't self-induced, or that the intoxication actually didn't lead to the particular breach. So by way of summary for contributory negligence, case law establishes and supports the concept of contributory negligence, that the plaintiff may be partially responsible for the harm suffered, and we've got our case of Manley and Alexander to help there. If it's alleged that there was contributory negligence, Section 23 says that we judge the plaintiff's breach of duty with the same criteria that we use for the defendant. So that means we go to the criteria under Section 9 and now apply that to the plaintiff rather than the defendant. And we've also established via Section 47 that if the defendant raises contributory negligence, it will be presumed if the plaintiff is intoxicated at the time that the breach occurs. So that brings us to the end of the particular reasoning or rationale behind negligence, the 3 requirements and the 2 defences. We might do a short summary vodcast to try and summarise how these all fit together and the key things we need to remember.